Next case is Courts versus Agency for Healthcare Administration. Okay, are both sides ready in this case? You may proceed.
May it please the Court. My name is Ann Swerlick, and my co-counsel, Cindy Huddleston, seated at counsel table. We are both representing James Courts, the appellant in this case, and we'd like to reserve 3 minutes for rebuttal. The issue before the Court is whether the Agency for Healthcare Administration, AHCA, properly terminated Mr. Courts' 2 weeks of companion care services that he had been getting on an annual basis through the Medicaid waiver program for several years, and also whether they improperly denied his request for an additional 2 weeks. Mr. Courts had an accident about 10 years ago, right after he married Carol Courts, that left him with quadriplegia. And as a result, he needs assistance with all of his activities of daily living. He cannot be left alone in the event of an emergency.
Excuse me for interrupting, if the Agency for Healthcare was required to follow the definition of respite care, not saying you admit that at this point, but if they were required to follow that definition, can you win?
Yes, Your Honor. Our position is that those, first of all, the definitions that are in that waiver application, and it's a form that the federal government gives the states to complete, to tailor their particular waiver program with various services. And as you can see from the record, the form has a variety of services with suggested definitions and a checkoff box for what services they want to provide. Those services are not mutually exclusive of each other. For example, there are checkoff boxes for skilled nursing care, private duty nursing, attendant care. All those elements, those service definitions have elements that overlap with each other. And we would assert in this case that the definition of companion care, which is non-medical supervision and care, has nothing in it that requires the caregiver to have to be there at all times when those services are being provided, or if the caregiver is absent, that they have to be absent for a particular purpose. So we would assert...
There could be 2 caregivers.
Yes, there could.
Okay.
And
I guess what I'm having a problem with, help me here, is if clearly what happened here appears to be within the definition of respite care. And I'm not saying that definition is applicable, but the definition within that waiver application, are you contending that what went on here does not meet that definition?
Well, the definition talks about the need to provide services due to the short-term absence of the caregiver or relief of the caregiver. And again, relief isn't really defined, but a common understanding is that would be to relieve the caregiver from the stress of the daily responsibilities of providing care. And clearly in this instance, Mrs. Courts, who is tending to an elderly and infirm parent, was not engaging what we would commonly consider to be relief. Our position is that the services that were provided in this case squarely fall within the definition of companion care. That is a definition in the approved waiver application of the state.
Well, counsel, are you saying that the respite care is care that is provided to someone who is not otherwise receiving this assistance? In other words, someone who is totally being cared for by family members, and the family members need to be absent. That's respite care. But if someone is already receiving the personal care services that the appellant was receiving, that providing additional services when the part-time family caretaker must be absent is not respite care, but simply a continuation of the regular services. Am I understanding? Am I missing your argument?
Right.
I don't want to put words in your mouth, but I'm just struggling with the argument.
It's a little bit like what Judge Wolf described earlier in another case, Jell-O, because we don't have...
That's my experience with Medicaid cases, because the law that we are quoted, it shows up in forms and checklists and things like that, and not in a rule or a statute that
Exactly.
we're familiar with.
There is no definition of respite care that's in law. There's no federal definition. There's no state policy or rule. What the state has done is merely lifted a suggested definition and a preprint of a form that the federal government sends out.
Well, why shouldn't the agency be given some deference in construing provisions of this waiver application?
Well, first of all, the line of cases that the agency has cited to in its brief for deference refers to deference to statutes that are being administered by the agency and that the agency is responsible for enforcing. In this case, it's the Centers for Medicare and Medicaid Services, which is the federal agency that is in charge of approving these waiver terms and enforcing them and determining if a state is out of compliance. It would be their interpretation that would be due some deference. And as you can see on the form, that respite definition is clearly just a suggestion. The state is free to alter those definitions, any of the service definitions, and free not to include it. One explanation, and this might be...
Help me here, though. You say the state's free to alter it. I don't think anybody's contending that the state altered it here, the definition of respite care. And I went in and read the Code of Federal Regulations, which again is like Jell-O to me, but are you contending that if the state said in their application that they were not going to provide respite care, and then they tried to pay out for respite care, that the feds couldn't come in and say, we're not paying for this? You understand my question?
I believe so, Your Honor. Our contention is, yes, the state could impose a limitation on companion care services to state that they would not be used for the purposes of respite. But if they're going to put a limitation like that, they need to be clear in the waiver application. And so the government, the federal government that's in charge of overseeing this and approving it, knows exactly what it's approving.
Okay. Tell me, I know you say simply not checking the box wasn't doing what you just said. But if they had clearly said in their application to the feds that we are excluding respite care, and then they tried to pay for respite care, could the feds have come in at that point and said, we're not paying for it?
I believe so, yes.
Okay, so you're not contending that the application wouldn't be binding on them. Your contention is that the application wasn't sufficiently clear.
Right.
Do you understand what I'm asking? Because I'm trying to understand your argument.
Right.
But it seems to me one of the arguments that you've made is that consistently up until this case, the agency had allowed for what they now call respite care, had provided for that. They now call it respite care. And that this change is a change of agency policy that is a reinterpretation, if you will, of the waiver terms that they have not provided for by rule or explained. So that based on our case law, we should reverse because they've changed their policy in midstream without any adequate explanation.
Exactly. And what we're contending is that if they were to do that, they would have needed to amend their waiver application and promulgate a rule that would have clearly set forth that limitation. And
Well, help me, because I'm,
okay.
again, I'm trying to understand the argument here. If they had clearly done it in the application, would they have been bound by the application? I understand you're saying that it wasn't clearly done. Would they have been, if they had clearly said that in the application, would they have been bound by that?
If those were the terms that the federal government approved, yes, they would be. And I think what we're trying to say is they are bound by the terms in the application that the federal government has approved. And that respite definition that they're trying to rely on, we would contend is not part of their application. It has no force of law.
But isn't this, what was a renewal request document,
Right.
set up for checking off what they will provide and not checking off what they won't provide? So isn't by implication the process means that they've elected not to provide respite care as defined in this form?
Well, again, we go back to, if you look at all those definitions, they're not mutually exclusive. And, for example, you could have a state that decides, we're not going to provide companion care. That's just not a service we're going to provide on an ongoing basis. But we will provide respite care. And essentially, the services that they'll be providing through respite care is companion care. In the case here, Florida elected to provide companion care, didn't put any limitations on the number of hours that people could get companion care, or any limitations on the primary caregiver having to be there, or only having to be there, or being able to be absent only for certain purposes. None of that is in there. And as Judge Van Nortwood stated, this is just a sudden and inexplicable shift of the agency's interpretation of the waiver, which is not supported by any change in the law. There's nothing from the federal government stating that what you're doing is not in compliance.
Let me interrupt for a second. You're down less than 3 minutes, but I'm going to give you a little leeway because I think it's an important issue. I'm trying to understand it. Go ahead.
Okay.
But getting back for a moment, counsel, is it your position that this agency has treated your client differently than other applicants for this particular service?
Yes, Your Honor, and we attached Mr. Parker's final order that was issued the same day. He, too, is a male with quadriplegia. His mother is his caregiver. They had been getting these services, additional companion care hours, when mother was not able to be with the waiver enrollee, including when she had to go out of town to visit relatives. And in that case, the hearing officer upheld the use of those hours.
So it's your position that this Parker case is similar to this case in terms of the facts, and because the agency has treated the Parker case differently than the facts of your case, then it's unfair to your client in terms of due process.
Exactly.
Now I'm sure we'll hear from counsel that appellee as well as not the Parker case to distinguish you from the facts of this case, but are you also alleging that companion services and respite services are different? Are they the same?
We are alleging essentially that under the umbrella of companion care, there is nothing in the terms of that service definition that would preclude companion care hours being given when the primary caregiver is absent from the home. And in fact, I think the agency would agree with that.
And in fact, that was done with respect to the appellant.
Yes, and with respect to Mr. Parker.
Right.
Thank you.
Tell you what, I'm going to give you 3 minutes. So I'm going to add 2 minutes to your time. If you would also add 2 minutes to the appellee's time.
Counsel, can you distinguish the facts of the Parker case from the facts of this case?
Yes, I can,
You
Your
can
Honor.
tell us who you are first. Yeah.
My name is Tracy Cooper. I represent the Agency for Healthcare Administration, the FLA. The difference between Parker and this case is not in the law. The law was the same in both the cases. The difference was in the facts. If you look at the facts of Parker, the testimony in that case was that the individuals, the beneficiary was using part of his time appropriately. As a matter of fact, he was using most of his time appropriately when his mother was going to run errands, was going to shopping, doing things that benefited Mr. Parker directly. In this case, the testimony at trial from Mr. Courts and from Mrs. Courts was that 100% of the care that he was receiving as companion care services was being used for respite services when the wife went to Pennsylvania to visit with her relative.
Okay, help me here for a second. If there had been two companion care people caring for Mr. Courts, and the wife had left, she was one of the companions, and the wife had to leave for 2 weeks, and the other person that was providing companion care continued to give it, would that have been respite care?
Your Honor, I think there's a distinction I need to make here. In this case, Mrs. Courts was not getting paid for staying with Mr. Courts. She's legally responsible for doing that. Okay, so she wasn't getting paid. So this isn't a substitution of services. It's not. It's something additional. We give him companion care so that she can go do things that benefit him. We don't switch it out. We don't allow.
What if she became ill, was hospitalized?
Well, in that case, we'd have to have a different provider.
So, but would that be companion services or respite care?
It would be, well, we'd have to change his plan of care at that point, in which case we could do companion services, we could do personal care services, we could do whatever he needs. But that's not the issue here. She's not incapacitated. She's leaving for a purely personal reason.
But the definition of respite care you're relying on doesn't use incapacitated. It says short-term basis because of the absence of those persons normally providing the care. If she's absent in the hospital, the definition would seem to apply. I mean, I'm struggling with, do you acknowledge that consistent up until the facts giving rise to this case, the agency allowed companion services to cover periods of time when Mr. Court's wife had to go take care of her parents?
It was given to him. It should not have been.
Well, but wasn't that was it that the agency then decided, whoops, this is respite care, not companion care?
What actually happened in this case, Your Honor, is that the Department of Health carries out the day-to-day operations of the program for us. And the Department of Health apparently had a misunderstanding as to what they were supposed to be given.
So it's your position that the agency was providing these services beforehand to the appellant. However, it was providing these services in error.
Exactly, Your Honor. And once we discovered the error, we have to immediately terminate those services because the approved waiver application doesn't allow us to provide them. We'd be in violation.
And if you continue to provide these services, you would have been in violation of the waiver application?
Yes, sir. And we can't do that. We don't have the money to provide 100% of the services. Our program could be terminated. All 300 beneficiaries could be out money. We can't afford those possible consequences to help one beneficiary. As much as we'd like to be able to give them those services, we can't.
Help me here, and I'm not sure it's in the record, but help me. Who makes the determination on whether they check that box for respite care?
There's a negotiation between the federal government, the Centers for Medicaid and Medicare Services, and the Agency for Healthcare Administration, which is the state agency that is responsible for our Medicare program and our Medicaid program. And basically, we have to decide what we want to provide based on what we have the money to provide, because we have to match the funds that the federal government gives us. So if we don't have enough funds in the Medicaid program to pay for respite care, we can't ask for respite care from the
So you're
federal
basically saying that the legislature makes that decision by the amount of money they provide?
To a certain extent, not entirely, but we have to decide what is the best thing for most of our beneficiaries when we're making those determinations. And most beneficiaries would rather have maybe more personal care, more companion care than respite care. In addition, Your Honor, this is a bare-bones program.
But it strikes me here that decision, the testimony here is undisputed that the appellant, if left alone, would be required to go into a hospital or nursing home. I mean, so it seems, I mean, that's how I read the fact that the agency was allowing for these services to avoid that bad result.
Your Honor, I think that's what the Department of Health was doing, and what they were doing was the wrong thing at the time.
It's probably the right thing, but maybe it was contrary to what the way the waiver is being interpreted.
Yes, sir. It was legally incorrect. What they should have done was helped. We've got a community support coordinator is available to these beneficiaries, and they can go in and help them find church services, other groups that will help care, do those companion services for free, or help them find it at a reduced rate. We've also, and if he does go into a nursing home, the difference in that is that this Medicaid waiver is not paying for that. It's another Medicaid program. So this Medicaid program is only allowed to spend a certain amount of funds. And it's kind of a flip-flopping. It's maybe not the best situation possible, but it's what we've got to work with.
Now, in the appellant's reply brief, the appellant cited to a Washington appellate court decision that they argue stands for the principle that an agency like ACA here can't rely on the boilerplate provision in the waiver form. How do you respond? I mean, I find their rationale somewhat persuasive. How would you deal with that case?
Well, Your Honor, Gasper, which is the case you're talking about, that involved a different situation than here in some respect. In Gasper, what happened was they applied for 3 or 4 waivers, and then they went back and they made a rule that said we're going to discount the amount of services they get for shared living. In other words, if there are several people, if the beneficiary is living with someone, we're going to not pay that person as much money to take care of this beneficiary. That rule was adopted after the terms of the waiver program. So what the court said in that case was that the federal government did not approve those additional terms. It did not approve that shared living rule, and therefore it violated the comparability clause. We don't have that situation here. We don't have a rule. We're looking at the approved application. We're looking at what the federal government approved. We don't have that extra stuff here.
Counsel, there was a rule that was approved subsequent to the fact of this case. Is that correct?
Yeah, I'm sorry, I don't know.
There was a rule that applies to the facts of this case that was approved by the
No,
agency.
Your Honor. We now have a rule. We didn't at the time that Mr. Courts was services were terminated or denied.
Okay. Now, that rule did not apply to the facts of this case.
No, sir.
Thank you.
Okay, so my understanding, let me go back to the case out of Washington, is that you say that they were making a change by the rule, and the rule was never approved by the federal government.
Exactly.
Where this application has been approved, not necessarily specifically the portion on respite care.
The whole application was the application that the federal government gave us. It was the application that we filled out. It was the application they approved. That's the only law we're going by in this case, Your Honor.
But isn't that what happened in Gasper? At least as I read the case, they didn't check off the check off concerning waiving comparability requirements.
Your Honor, our actual we have a comparability waiver. We do. It's like number 10 in the approved application. So we don't have that problem in this case. We have it waived. We don't have to go back.
No, I understand that. I'm not saying that. That's not my question. My question is that case, as I read it, is being the appellant is arguing that this case stands for the principle that simply by not checking off, you cannot rely upon that lack of checking off as being approved by the Center for Medicare and Medicaid Services.
I don't agree with that, Your Honor. The center was the one that designed the application. Obviously, if they wanted us to do something affirmative to accept a definition, they would have given us a better choice than to check the box. We checked the box. Everything was included. We didn't put in a different definition of respite care, which we could have. We haven't attempted to do anything afterwards to amend those definitions that were in that approved waiver. So that's the rule of the case. That's what the federal government expects. When we promise not to provide respite care, that's what they're going to go by. And we just can't risk the possibility that when we go to federal court on this, that, you know, we're going to get slammed and lose all this money and lose the benefits that these beneficiaries need. You know, it's not just paying money back. They could possibly terminate the program on us. That's 300 beneficiaries out of all the care that they're getting currently, and they might have to go back to nursing homes.
But if we were to interpret the application as being consistent with what the agency has done through the history of their dealings with the appellant, that is, it's perfectly consistent to treat these services as companion services when the appellant's wife was not there. That interpretation would at least be a basis for showing that there's no violation of the application, would it not?
Your Honor, the thing is that we can't be held to a mistake. If we're held to a mistake and we go back to the federal government, then what do we have to say? We screwed up, and so we should have to always pay these people when we really can't do it.
So it's your position that if you continue to make these payments, you would have been in violation of the application, and you would have ran the risk of losing all your federal funding?
Exactly.
Okay,
Exactly
Judge
right.
Van Orwerth's question, though, to you, and that was, if we decide that this is actually companion care, does that provide you cover from the federal government?
I don't think so, Your Honor, because that would make not only Mr. Court's particular situation would be companion care, but it would make all these other situations that we terminated at the same time companion care. The thing is, this is what respite care would be for, is for her to do something purely personal for herself, or that only has an indirect benefit to Mr. Court.
But what you're saying here, and it concerns me a little bit, is we can't interpret the application. Who can?
The federal government, Your Honor.
And that's it. So we're just in the wrong forum to do this.
We are ACCA's job in this is to transfer money. That's what we do. We get money in from the federal government, we add to it, and we give it to the beneficiaries. We don't have a whole lot of discretion in interpreting the application here. We have to follow it as closely as possible. And
But if, on my hypothetical about Mr. Court's wife having to go to the hospital for a couple of weeks, if that's not respite care, then you would be interpreting. I mean, that's what interpreting is. It's applying something to the facts. And what I'm saying is, rather than characterizing what you have been doing as an error, I would characterize it as an interpretation, applying the language to the facts. Now, maybe that there's been a change in that interpretation.
Yeah, and it goes back, because I'm a little concerned here. If what you were doing before was an interpretation, don't we have a right to review that interpretation of a state agency?
Your Honor,
That's not to say the federal government can't overrule us later on, but don't we have the right to?
I don't think it was an interpretation. I think what we were trying to do, and it was mistakenly carried out completely contrary by the Department of Health, is we were trying to say anything at all that falls within this definition of respite services, we aren't going to allow.
Counsel, under the facts of this case, Mr. Court's wife was not in the hospital for 2 weeks. Is that correct?
No.
Okay. In fact, she was caring for an ill relative in Pennsylvania.
Yes.
Thank you.
Yes, Your Honor. And again, you know, we feel sorry for, but there's only so much we can do. It's a bare bones program. We have to give out money where we can, and if we were to allow everybody who wants companion care services for respite purposes to get the care, we'd be in violation of the program and we wouldn't have enough money, quite simply. If anyone has any more questions, and if not, I will rest on my brief. Thank you.
I want to refer the court to the Stewart case, which is another case this court decided involving a Medicaid waiver, where that's exactly what the court did, is interpret the provisions of that Medicaid waiver program. In that case, a child needed an environmental adaptation in order to use his wheelchair in his home, and the state had denied that service, saying it wasn't permitted under the terms of the waiver.
I'm not sure I'm buying off on this fact that we can't interpret an agency's interpretation or review an agency's interpretation. But what I am getting hung up on, very honestly, and it goes back to the first question I asked you, if by not checking the application, is that sufficient? If we determine that is sufficient for the state to reject respite care, I'm having trouble seeing that this is not respite care. I mean, I see where the two overlap, but because companion care is broader, it can include respite care, doesn't mean they can't exclude a portion of companion care.
Well, and I think, in fact, if you look at the final order, what was actually applied by the hearing officer, even though she cites to that pre-printed suggested respite definition, in fact, her conclusion doesn't turn on the fact that the caregiver isn't there, but that the caregiver is tending to family matters. Whereas in the Parker case, she again concludes it's when the caregiver cannot be there, which could meet the definition of respite.
But I think what the department's interpretation is that if the caregiver is away of taking care of things for the benefit of the patient, that's not respite care. And that's how they distinguish Parker.
And again, that's a limitation that they've put. Again, it's not using that respite definition that's in the waiver form. It's a completely different standard, and it's a limitation that's not anywhere stated in rule or in the waiver application.
Counsel, had the agency checked the box for respite care, we would be in a different posture in this case, wouldn't we?
That's correct.
Now, look under the definition of respite care. It says services provided to individuals unable to care for themselves, furnished on a short-term basis because of the absence or need for relief of those persons normally providing the care. The time that the wife is away in Pennsylvania caring for a sick relative, is it your position that would not come within the definition of respite care?
Well, I think, again, yes, it could come under that definition. But there's nothing that precludes companion services from being provided when the caregiver is not there. And again, it goes back to the point that those definitions are not intended to be read in a mutually exclusive way. And I would point out in the Gasper case that Judge Van Nortwick spoke about, the state in that case had indicated it was waiving the comparability requirement, which basically meant that comparability is a requirement of Medicaid law requiring groups to be treated the same. And in that case, they were going to treat one particular group differently by allowing them fewer caregiver hours. And the court said that limitation is not spelled out in the waiver terms, and the general waiver of comparability is not sufficient for the state to impose this additional limitation. It wasn't a limitation that was reviewed or approved by the federal government. And we would urge this court to give effect to the plain meaning of companion care and the language in that definition.
Okay, Counselor, your time is running. Thank you very much. Being no further cases in front of the court will stand in recess till this afternoon.